Oh, yay, oh, yay, oh, yay. This Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Clerk Hibner, and welcome everyone to this special setting of the August docket. We have one case on the morning docket. Each side is given 25 minutes total. There was a request made by defense for the appellant for that additional time, and it was granted. I'd like to thank you, attorneys, for the extraordinary effort you had to make to be here today. I know this is not a routine setting, and we very much appreciate the effort that you make to be here today. I want to thank the AOC staff and the folks that make this possible, this Zoom session. Today, your panel is the August panel that was originally set in Memphis, Tennessee. We are Zooming this session as it is from Maryville, Tennessee, Judge Kelly Thomas. From Franklin, Tennessee, Judge Tim Easter, and I'm John Everett Williams from Huntington, Tennessee. Happy to be with you here today. With that, are there any preliminary matters that anyone has? Mr. Clerk, if you don't mind, just call the next case.
Jesse Dotson versus State of Tennessee.
Harris, you're up.
Thank you, Your Honor. Good morning. I'm going to please the court. My name is Andrew Harris, and I am counsel for appellant Jesse Dotson. Thank you for allowing me to present oral argument on his behalf. I'm prepared to address any claims in our brief and any questions you may have. I'd like to focus our discussion this morning on Claim 8, counsel's ineffectiveness of failing to present mitigating evidence at Mr. Dotson's capital sentencing, and Claim 10, the funding issue, to the extent it informs Claim 8. In this case, trial counsel's paltry penalty phase presentation was limited to one lay witness, their mitigation investigator, Lori Shettles. Ms. Shettles investigated Mr. Dotson's life history and provided counsel with a 104-page document, which included a timeline of Mr. Dotson's troubled life history, summaries of her mitigation witness interviews, and a list of mitigation themes. This 104-page document detailed mental illness, cognitive impairments, learning disabilities, speech and language impediments, physical abuse, emotional abuse, parental neglect and abandonment, exposure to domestic violence, poor nutrition, poverty, polysubstance abuse, and deprivation. The jury never heard this readily available mitigating evidence, however, because counsel prepared Ms. Shettles for a testimony by doing nothing more than telling her to just talk. That was counsel's words when he testified at the post-conviction hearing. As a result, counsel's case for life consisted of just 36 pages of transcript in which Ms. Shettles barely scratched the surface of the mitigating information she had developed and previously provided counsel. There were no exhibits, there was no expert mental health testimony. And now counsel provided the wealth of mitigating evidence available to them. Counsel could have made a powerful case of life, and counsel were ineffective for failing to do so. Marty McAfee, the defense counsel responsible for the penalty phase presentation, conceded at the hearing that he had no game plan if the case proceeded to a penalty phase. Trial counsel believed the only way to save Mr. Dotson's life was by getting him acquitted. Thus, despite his role as sentencing phase counsel, Mr. McAfee devoted the overwhelming majority of his time, he said well over 75%, preparing for the guilt-innocence phase of the trial. As a result, trial counsel in this case did a cursory mitigation investigation and presented only Ms. Shettles at the penalty phase. Despite the obvious importance of Ms. Shettles' penalty phase testimony, Ms. Shettles did not recall meeting with Mr. McAfee about her testimony prior to testifying at Mr. Dotson's trial. Instead of preparing his sole penalty phase witness to testify, Mr. McAfee simply instructed Ms. Shettles to just talk. I'm sorry, and I regret I did not ask for time for rebuttal. I'd like to reserve 5 minutes. I apologize for not asking at the beginning of the hearing. Ms. Shettles' entire direct examination comprises 36 pages of the trial transcript, much of which discusses her background and what life is like in prison. There may be 10 pages of transcript where Ms. Shettles actually talks about Mr. Dotson's background. While she mentions he suffered physical abuse and parental neglect, that he had a learning disability and disciplinary problems in school, and had several juvenile adjudications, she made only a passing reference to these themes, and she failed to describe Mr. Dotson's background in any detail. Thus, the trial transcript demonstrates that counsel's performance was deficient. Mr. McAfee testified that while he believed Mr. Dotson suffered some pretty significant trauma as a child and wanted to present the trauma to the jury in an attempt to persuade them to spare Mr. Dotson's life, he said there just wasn't a lot there. Those are his words. But a review of counsel's file belies his recollection. Documents in the file set up mitigating evidence that counsel could have and should have presented at the penalty phase. Ms. Shettle prepared and provided the counsel the 104-page document detailing Mr. Dotson's social history and containing a wealth of mitigating evidence, little of which was presented at trial. If trial counsel had prepared Ms. Shettles to testify, the jury would have had before it a plethora of mitigating evidence, making the case for life. Now, I'd like to just talk a bit about comparing and contrasting the timeline with what was said at trial. Now, as I said, her penalty phase testimony, it's really only 10 pages where she discusses his background and really just gives cursory and kind of bullet point information. But here's the mitigation timeline, which is Exhibit 42. It's 104 pages of just dense material. And for example, as far as abuse and neglect at trial, all Ms. Shettle says is Jesse Sr., Mr. Dotson's father, was abusive to his mother on more than one occasion. The children saw this, and that the mother was leaving the children home alone. That's all she says about abuse and neglect. When you look at the timeline, there's just a wealth of information that was developed that counsel could have spoke about. The word abuse never, as far as like child abuse, never comes up in Ms. Shettle's testimony. But for example, when you look at the timeline, it has information such as Mr. Dotson's biological father was physically and verbally abusive to Dotson, his mothers and his siblings. He would yell and beat Mr. Dotson. Mr. Dotson's mother would often call her father to help due to the physical he suffered at the hands of Mr. Dotson's father. Mr. Dotson's mother used a belt to whip the children. Mr. Dotson's sister ran away from home because of the beatings. There were formal reports made of child abuse and neglect in the Dotson household. Mr. Dotson's mother never told her children that she loved them or showed them any affection. There's also a document at the end of the timeline. It's also admitted as Exhibit 17 called Significant Life History and Themes, what lists kind of mitigation themes. It's a 3-page document prepared by Ms. Shettle summarizing the themes. And that also talks about how he witnessed domestic violence. And she says, please note articles regarding effects of witnessing domestic violence, but there's no discussion of that or those articles or that type of information at the trial. She talks about excessive corporal punishment by both parents, fists, extension cords, belts, fan belts. She talks about how Mr. Dotson witnessed inappropriate sexual behavior by his mother. And also, there's also evidence of mental illness and impaired intellectual functioning, which is not presented at trial. All Ms. Shettles testifies to, she says Jesse was diagnosed with a learning disability in reading and math. When you look at the timeline, there is just so much more information to work with and could have been presented to make out the case for life. So for example, the timeline talks about how Mr. Dotson's grandmother observed that he seemed to have something wrong with him from the time he was a small child. At the age of 14, Mr. Dotson is referred to a mental health center where he was diagnosed with a specific learning disability that previous testing indicated an IQ of 84. Results of testing at that time noted that Mr. Dotson had an IQ of 80 and that the treatment plan indicated he has significantly impaired intellectual functioning. At the age of 16, a psychological assessment reflected limited intellectual functioning. At the age of 17, Mr. Dotson's mother informed police that Mr. Dotson needed some type of rehabilitative services. At the age of 20, testing showed that Mr. Dotson recognized words at the 2nd grade level, spelled at a 3rd grade level, and that his math abilities were at a 4th grade level. And that when Mr. Dotson would get angry, he would sometimes beat his head against a wall, even a concrete wall, in order to soothe himself and calm down. There were also mitigation witness interviews attached to the timeline. There's one with Pam Shelton, who was Mr. Dotson's girlfriend, who told Ms. Shells that when Mr. Dotson was 10 or 11 years old, his sister Nicole initiated sexual activity with him and made Mr. Dotson and his brother perform sex acts on her. And Ms. Shells failed to testify about these details during her sentencing phase testimony. So it's really this isn't cumulative, it's really night and day what counsel presented at the penalty phase, the extent anything was presented and what could have been presented. You know, you're talking about 10 pages of transcript versus 104 pages of this dense material. Ms. Shells could have been on the witness stand for hours, if not days, detailing Mr. Dotson's life history. And trial counsel also failed to use and introduce evidence of the records collected by Ms. Shells and interview memos that form the basis for the timeline. A review of the defense team files indicates that there are more than 1,000 pages worth of material that counsel failed to utilize. During the hearing, counsel said that there's not much here, that the memo said there's not much here, but a review of the memos indicates that Ms. Shells never says that. And in fact, there's a lot of helpful information in the memos that form the basis for that timeline. Mr. McAfee also testified that Ms. Shells was the only witness he called at the penalty phase because, quote, I think we could get all the information out through her, end quote. But comparing and contrasting the testimony with the information, just what little I went through with the court right now, what was available to counsel and contained in their file indicates that Mr. McAfee was very wrong. And so, you know, Exhibit 18, which is a September 8, 2010 handwritten note in trial counsel's file. This is just 12 days before the hearing. It's entitled Mitigation Meeting Regarding Theme, shows that counsel's just scrambling and trying to put together the case for life at the last minute. So as a result of counsel's failings in sentencing Mr. Dotson to death, the jury had very little mitigating evidence before it because counsel didn't prepare Ms. Shells to testify and failed to present the wealth of the mitigating evidence contained in their file. The so-called case for life fell far short of the minimum expected of capital defense attorneys. In this case, there's readily available mitigating evidence for the taking. Mr. McAfee made clear he wanted to present significant trauma that Mr. Dotson suffered in making out the case for life. And accordingly, counsel could have had no tactical or strategic reason for failing to develop and present the mitigating evidence developed by Ms. Shells and found throughout their files. Doing so would have been consistent with what little penalty phase strategy they formulated. Now, counsel also failed to present mental health expert testimony, and counsel in the capital case have a duty to make an informed decision about the presentation of expert mental health testimony. Mr. McAfee agreed that a mental health expert is essential to defending a capital case. Counsel were aware of strong indications of mental illness in this case and retained James Walker, a neuropsychologist, to evaluate Mr. Dotson. Counsel conceded that Ms. Shells is not qualified to make a mental health diagnosis. A mental health expert could explain the effects of trauma, including the resulting mental illness. The counsel failed to make effective use of Dr. Walker and presented no expert testimony at the penalty phase. Filing a motion for the services of Dr. Walker, counsel provided an affidavit from Dr. Walker, which talked about how Mr. Dotson had a long history of psychological problems and possible serious mental illness. And then Dr. Walker interviewed and conducted a forensic psychological evaluation, including neuropsychological testing of Mr. Dotson in advance of the trial. And Dr. Walker provided a draft report which indicated that Mr. Dotson is a severely impaired individual who is brain damaged and suffers from adjustment disorder with depressed and anxious mood, alcohol dependence, cannabis dependence, and has a GAF level of 60. And while Dr. Walker's report provided that Mr. Dotson has antisocial personality characteristics, he did not diagnose him with antisocial personality disorder. But after Dr. Walker provided counsel with his draft report, counsel never followed up with him, never discussed the results of his testing, never discussed his conclusions, never asked him to finalize his report, and did not call him to testify on Mr. Dotson's behalf. This report provides significant mitigating evidence that could have been presented during the sentencing phase of Mr. Dotson's trial. The United States Supreme Court, the Sixth Circuit, and our Tennessee courts have repeatedly found counsel ineffective for failing to present mental health expert testimony, especially evidence of brain damage in a capital sentencing proceeding. And that is exactly what happened here. Courts have found this type of mental health testimony to be unquestionably mitigating and unquestionably compelling the jurors. And there's a reasonable probability that at least one juror would have voted for life had they heard organic brain damage. Counsel talked about that they were concerned about presenting the testimony because of antisocial personality characteristics. But Mr. McAbee explains he doesn't know the difference between characteristics and disorder, and that when they proceed to the penalty phase, the jury already had convicted Mr. Dotson of 6 homicide counts and 3 counts of attempted first-degree murder. So it wouldn't surprise him that someone convicted of these offenses might have antisocial personality characteristics, and no new harmful information would come in with that reference in Dr. Walker's report. As a result, he said our analysis probably wasn't on point, and there was a lot of helpful information in Dr. Walker's report. So counsel's decision not to present Dr. Walker's testimony in the sentencing phase without fully exploring what mental health testimony he could provide was unreasonable, and because Dr. Walker's evaluation and his testing revealed significant mitigation. So as a result of counsel's blunders, not only did they not hear from Ms. Shuttles and all she could have provided and all that information in the timeline, but they also heard no evidence about Mr. Dotson's mental health disorders, including organic brain damage, adjustment disorder, and polysubstance dependence. And that a reasonable probability exists had jurors heard such evidence in conjunction with the neglected life history developed by Ms. Shuttles, at least one juror would have voted for a sentence of less than death. And I know in this case, there's a lot of aggravation that was found. I just want to talk about the fact that the jurors have made clear that mitigating evidence can make a difference regardless of the facts of the underlying offense. And we talked about that in footnote 10 of our opening brief. We referenced an article by Russell Stetler, which identifies nearly 200 highly aggravated death penalty cases which went to trial, cases with child victims, law enforcement victims, or multiple victims, where jurors did not impose death sentences. And I want to point out 2 highly aggravated Tennessee trials where jurors returned life sentences. In 2009, a federal jury in the Middle District of Tennessee convicted Jamal Shakir of killings in 3 states, the shooting of a 3-year-old, and torture of 2 of those victims, and sentenced him to life. In 1996, a Montgomery County jury convicted Courtney Matthews of killing 4 people at a Taco Bell restaurant and sentenced him to life without parole. And in fact, in 2019, this court found that trial counsel was ineffective for failing to subject the prosecution's case to meaningful adversarial testing in the post-trial phase, and remanded the case for a new motion for a new trials proceeding. So even there, in light of the aggravation, counsel found, this court found that there was ineffective assistance of counsel. We also know about many highly aggravated capital trials, which result in life sentences. Zacharias Massawi, James Holmes, Brian Nichols, Terry Nichols, and then the U.S. Supreme Court's granted ineffective assistance of counsel claims in highly aggravated cases, in Williams v. Taylor, in Rompilli v. Beard, in Wiggins v. Smith. And then to the extent that this court, so the case for life could have be made out with Ms. Shuttles or with Dr. Walker, but both combined would have been a very powerful and compelling case. And to the extent this court finds that the record is incomplete and we can't establish prejudice because we were denied funding, this case should be remanded with instructions to allow us to put on that evidence that we were precluded from doing so by the AOC director. So I also want to just talk about that Mr. Dotson's case is no different than Davidson v. State, where the Tennessee Supreme Court found ineffective assistance, where trial counsel failed to investigate and present mitigating evidence of the defendant's troubled background, brain damage, and impairments in functioning. In Davidson, Mr. Davidson suffered from severe lifelong cognitive impairments. During the sentencing phase, counsel presented no mental health expert testimony and only cursory social history mitigation evidence. They presented no records, despite the fact counsel had records that detailed Mr. Davidson's history of mental illness and trauma. Counsel also failed to make use of the mitigation specialist report. The same mitigation specialist in Davidson, it was Lori Shettles, and that 2 experts evaluated Mr. Davidson for post-conviction, and both found that he was brain damaged, and both diagnosed him with cognitive disorder, NOS, just like Dr. Walker has done in this case. So the court found this extraordinary amount of mitigating evidence not presented at trial, and the Tennessee Supreme Court found trial counsel held in their hands this compelling evidence that Mr. Davidson had a damaged brain and a tragic past, and the failure to submit any of this mental health evidence to the sentencing jury fell short of professional norms, and counsel's failure deprived their client of his right to effective assistance to counsel. As is the case here, had the jury been able to place Mr. Dotson's life history, brain damage, and mental illness on the mitigating side of the scale, there's a reasonable probability that at least one juror would have struck a different balance. The evidence unpresented by trial counsel reveals the kind of history the United States Supreme Court and our Tennessee Supreme Court have declared relevant to assessing a defendant's moral culpability. This trial counsel's failure to meaningfully investigate, develop, and present evidence of Mr. Dotson's brain damage and traumatic life history constitutes deficient performance, resulting in prejudice to Mr. Dotson, and he's entitled to relief. If there are no questions, Your Honors, I reserve the rest of my time for rebuttal.
You have your full 5 minutes, Mr. Harris, and very good time management on your argument. What would the state have to say today? And you need to unmute your microphone, please. Thank you.
May it please the court, Courtney Orr on behalf of the state. The petitioner, Mr. Dotson, was sentenced to 6 death sentences for the murders of his brother, Cecil Dotson Sr., his brother's fiancee, Marissa Williams, their friends, Shinji Robinson and Hollis Seals, and his 2-year-old and 4-year-old nephews. He was also sentenced to 120 years for the brutal stabbings and beatings of his 9-year-old nephew, his 5-year-old nephew, and his 2-month-old niece. Those children survived his attacks. On direct review, the Tennessee Supreme Court described the petitioner's crimes as, quote, some of the most horrendous ever committed in Tennessee, unquote. Today, we submit that the post-conviction court properly denied relief. As opposing counsel did, I will limit my argument mainly to the presentation of mitigation evidence at the penalty phase of trial. Simply put, the petitioner cannot demonstrate that counsel was ineffective for his presentation of mitigation evidence. It is true that Ms. Shettles was the sole defense witness in the mitigation hearing, and that she testified primarily about the petitioner's childhood, his exposure to abuse, including the abuse from his father, his spotty educational history, his learning disabilities, and neglect that he suffered from both his mother and being left in the care of his sister, and even went so far as to detail how the petitioner and one of the victims, Cecil Dotson in this case, were reduced to stealing food and money from their grandmother to try to get something to eat. The petitioner now points to several things within Ms. Shettles' mitigation timeline to say that counsel should have presented that evidence. However, counsel was not ineffective for failing to delve further into Ms. Shettles' timeline for 2 reasons. One, Ms. Shettles testifies at the post-conviction hearing that many of the petitioner's family members and many people within his life refused to help or refused to assist with the case. And the counsel did not testify, or excuse me, did not call any of those witnesses to testify at the post-conviction hearing to show, 1, that those witnesses would have been available, or 2, what their testimony would have been. To the extent that he is now arguing that counsel should have asked Ms. Shettles about that testimony, he did not ask her about that testimony in the post-conviction hearing either, and there is no indication that Ms. Shettles would have been able to testify as to what these other witnesses would have said. Both counsels at the post-conviction hearing testified that the entire defense team, both attorneys, the mitigation expert, and the mitigation investigator and the trial investigator worked together as a team, and they made all of their decisions together. So even though counsel had made a strategic decision to focus on the guilt phase of this trial because they believe that was the best chance to avoid the death penalty, it is simply not true that counsel made no preparations for the penalty phase. Instead, all 4 members of the defense team investigated this timeline. They were involved in all of these decision-making events together, and counsel was aware of what Ms. Shettles had uncovered in her investigation. They further made a strategic decision to rely on Ms. Shettles' testimony alone because they believed that Ms. Shettles would be able to get out all of the testimony about the petitioner's childhood and the abuse he suffered and any mental illness or mental effects that those would have caused without drawing any of the or many of the objections that an expert witness would have drawn. Indeed, Ms. Shettles did not have any objections to her testimony, even though she was able to testify about the petitioner's learning disabilities, his neglect, and the exposure to abuse he suffered as a child. To the extent that the defendant now argues that counsel should have presented those expert testimonies in the penalty phase of trial, he cannot show prejudice either. He did not present any of those expert witnesses at the post-conviction hearing. Without their testimony, both Black and Rule 28 show that he cannot show prejudice. Black says that presentation of those expert witnesses was necessary in order to show how those witnesses would have performed under cross-examination. And further, under Rule 28 of the Tennessee Rules of Supreme Court, the state had a right to cross-examine any of those experts in the post-conviction hearing. And by simply submitting reports or letters from these experts, which one are not subject to cross-examination, that does not show this court how those experts would have performed under cross-examination, and it deprives the state of its rights to cross-examine the post-conviction witnesses.
Did I correctly understand Mr. Harris to say that they sought funding in this case so that they could call those witnesses to trial, and that the AOC denied the funding?
The records partially supports that for only one witness. They did seek expert funding for 4 witnesses, Dr. Marikangas, Dr. Walker, Dr. Leo, and I forgot the 4th name and I apologize, it's not right in front of me. Agpar, that's the last one, I apologize. The only information that we fully have in the record is for Dr. Agpar, where the post-conviction court granted funding for $350 an hour for Dr. Agpar's services. The the cap under the rule for expert services is $250 an hour. Pursuant to Rule 13, the funding order was sent to the administrative office of the courts for prior authorization, and the administrative office of the court granted funding for $250 an hour and said that it would not grant funding above the cap because it was not permitted to. That decision was signed off by the Chief Justice as required by the rule. For the remaining 3 experts, the only thing we have in the record are the post-conviction court's orders granting funding. We have some statements from counsel made right before the post-conviction hearing to indicate that the AOC had also, he says, denied those requests for funds, but there's no letter or any indication of the AOC within the record to support what had happened. So as it relates to Dr. Walker's, Dr. Leo, and Dr. Marikangas, the record is not sufficient to know what happened. And therefore, that issue has been waived. For Dr. Agpar, we submit that this guy gets into his AOC funding issue. The AOC did not deny funding. It limited funding to what was available under the rule. And further, that does not deprive the defendant of due process for a post-conviction hearing. Instead, under the post-conviction rules, because this is a statutory procedure, the defendant is only entitled to a hearing in which he can be a full and fair post-conviction hearing where he can be heard in a meaningful time and a meaningful manner. Aoc does not extend to record or create a constitutional right to experts in the post-conviction hearing. There is no constitutional right to experts in collateral review. Does that answer your question, John?
Yes, as much as you can, I think.
Mr. Orr, am I not correct in recalling that these orders are actually signed off on by the Supreme Court? It's not
Yes.
actually the administrative offices of the court who's denying this. All of these decisions are made by the Chief Justice. Is that not correct?
Yes, Your Honor. Under the rule, it's the first determination is made by the administrative office of the courts. If the administrative office denies or limits the funding, then it goes to the Chief Justice. And that is what happened in this case. The Chief Justice signed off on this, and under both the letter and the language of the rule, the Chief Justice's decision was final. Further, turning back to the ineffective assistance of counsel, to the there is no indication in this record that counsel would have needed to have those experts funding in order to present at least one expert in this case. Here, even in his motion requesting experts funds for Dr. Walker, counsel said, we are not calling Dr. Walker, we're calling him as a fact witness, and as a matter of professional courtesy or to respect for his time, they wanted to pay him for his time within the court and his time within traveling. Dr. Walker had already done an examination of the petitioner, and they could have called him to ask him about this report that he had already done. And I believe in discussions of Dr. Walker's funding request and the AOC's treatment of that request, there was some discussion about, well, he is a fact witness, he is not an expert witness here. Here, Dr. Walker could have been called to testify about the report that he had already done, and that he was not called in this case. And further, just to take it back even to deficiency, counsel cannot show that, the petitioner cannot show that counsel was deficient for failing to call Dr. Walker. Dr. Walker, in his report, even though as counsel acknowledged there was several beneficial mitigation aspects in this report, within his report, he diagnosed the petitioner with, among other things, antisocial personality characteristics. Both through Mr. Skahan and Mr. McAfee testified that once they saw that, they knew that they would not present that evidence to the jury. They both said that they could not think of any label worse in the criminal justice system to present to a jury than something involving the word antisocial. That would not have inspired sympathy from the jurors, and they did not want to present that evidence to the jury. That is the definition of a tactical decision, which this court cannot second guess. And as I've already noted, Dr. Walker did not testify at the post-conviction hearing, and we cannot rely on his report or on his letter that is submitted for identification only to establish what he would have testified to had he been called at the mitigation and penalty phase of trial. The same is true of Dr. Leo, Dr. Marikangas, and Dr. Akhtar for their testimonies in terms of the prejudice side of this. Finally, the defendant faults the petitioner faults counsel for not calling Dr. Bishop, who they had consulted with for establishing a possible mental health defense. This was also a strategic decision that could not be second guessed by the post-conviction court. Counsel testified that Dr. Bishop was extremely reluctant to work on this case, and they had to convince her to do so. And when she finally did look into the petitioner's case, she could not establish a mental health defense or any sort of post-conviction or post-traumatic stress disorder defense without any beneficial diagnosis. Counsel elected not to call her. And again, she was not called at the post-conviction hearing, and we cannot determine what her testimony would have been had she testified in mitigation. Unless there are any further questions about this or the AOC funding procedures. We ask that you affirm the judgment of the post-conviction court.
Mr. Harris, you have your full 5 minutes for rebuttal, and it is rebuttal only, please. Your microphone is muted.
Thank you, Your Honor. As far as witnesses not being cooperative, this was an interfamiliar crime, so it's no surprise. And as counsel, Mr. McAfee and Ms. Shields testified, that certainly was the case. And that shows why even it was more important to thoroughly prep Ms. Shettles to get all the mitigation out through her, and also why mental health expert testimony was critical. They could have made the case for life with Ms. Shettles. They could have made the case for life with Dr. Walker or any mental health expert, and combined, it would have been a very powerful presentation. Ms. Shettles could have testified to everything. There's no requirement to put on lay witnesses to make out the case for life at trial or in the post-conviction hearing. She could have testified to everything in a 104-page timeline. She could have testified to everything in all the records she collected and all the interview memos, more than thousands of pages. It's routine for investigators and mitigation specialists and experts to take the stand and testify to the result, testify about the records they collected and the interviews they've conducted. There's no hearsay issues. In fact, in Green v. Georgia, the U.S. Supreme Court talks about how the rules of evidence are relaxed. The hearsay rules are relaxed in the capital sentencing proceeding. So mitigation specialists routinely testify all the time in capital trials and post-conviction hearings as to what the investigation shows.
So you're saying the mitigation expert could have gotten all the favorable proof in from Walker and the other experts through the records that she had brought together and therefore get rid of the necessity of calling the experts. Is that what you're saying?
She certainly could have testified to everything in the mitigation timeline, the 104 pages and the 1,000 pages of materials. I think the case could have been made out with Ms. Shettles, and she also could have testified to any evaluations that were done. But I do think, while you can make up the case alone with Ms. Shettles, I do think a very powerful case could be made out by both Ms. Shettles and an expert.
So why was Walker not called?
He was not called because counsel just dropped the ball. They never spoke.
No. I mean at the post-conviction hearing.
We tried to present him, but we were denied funding in which to do so. That's why he didn't testify. We made attempts to put on 3 mental health experts and also Dr. Leo. And we, as far as there not being any record of this, we discussed and laid out in the reply brief exactly what happened. We made repeated attempts and reached out to the Aoc director.
Briefs aren't records. So General Orr says there's nothing in the record to establish that the funding was denied. Is that correct or incorrect?
There was, we tried to supplement the record both in the trial court and in this court, Your Honor, and that was denied. And that we believe that was an error, because the court can't hold that we were unable to prove prejudice, and we can't be barred from presenting evidence and then argue that they failed to put on the evidence. We were entitled to put on this evidence, and there's any concern about that exit testimony, the remedy should be a remand for further hearing.
Okay, so did I hear you correctly that you asked to supplement the record to establish the denial of funding for Dr. Walker and the other experts, and our court denied it? Is that what you said?
Correct, Your Honor.
So we'll have an order that shows that denial, I take it, in our record.
Yes, Your Honor, and we attached that, and we referenced and attached it to our reply brief. It is.
Okay, thank you. We'll look at it.
And as far as Judge Easter's question, the funding wasn't denied by the Supreme Court. It was the AOC director and the Chief Justice acting unilaterally. The Chief Justice wasn't acting in his capacity as a judge. He was acting in an administrative function, and it's an administrative role. And as we lay out in our briefing, that was improper. because they didn't. And that as far as, not putting on, as far as preparing Ms. Shettles, they totally dropped the ball on that as well. They just put her on the stand and told her just to talk. And I asked the court to look at the mitigation timeline and look at those 10 pages of testimony. And it is really night and day. It's not cumulative. They put on a paltry presentation at the penalty phase, and they could have made out a very compelling case for life. And this is a case where the post-conviction court found that Mr. Dotson was entitled to this expert assistance, and that was denied without our opportunity to be heard and without due process. We're entitled to put on that evidence. And if the court has any concerns about that, if they don't think that we can make out the case based upon our arguments about Ms. Shettles and Dr. Walker's draft report, then the remedy should be for a remand for us to present that evidence in a new evidentiary hearing.
Mr. Harris, to be fair, isn't it the case that the funding up to a certain amount was approved by the AOC or the Chief Justice? Is that the expert wanted more per hour than the state was willing to pay? Is that not correct?
That was the case of Dr. Agarka, but both Dr. Marikangas and Dr. Walker willing to work for the state rate.
Thank you.
We are seeing some evidence in other cases about the funding issue becoming large. And one of the things that seems to me to be incumbent upon the defendants to possibly do in these cases is let the approving body know what the end result's going to be. I know you do not know at the first time if the expert is going to testify, but don't you think it's financial responsibility to ask them what they're going to charge to come at the end of the trial? So when you approve this witness, they'll stay within the budgets that are in the constraints of the statutory limits before you even hire.
Well, Your Honor, when we do file the motions for the experts, and at this point we had, I think, hit the $25,000 cap, but the rule allows for extraordinary circumstances to exceed that cap, and it's routinely exceeded in capital cases, usually well in excess of $25,000. So I think Mr. Dotson's case might be the first and only capital post-conviction case where he's held to this $25,000 cap. And also, I've been litigating capital post-conviction hearings cases for a very long time, and I've never had a case where we're litigating ineffectiveness in the penalty phase and we're not allowed to put on mental health evidence. It's really kind of beyond the pale what happened, and it's fundamentally unfair, and it offends due process.
Okay. Well, I thank you. I hope you have at least felt today we've given you adequate time to argue your case with the additional 5 minutes and the additional time that we've allowed you today, as well as the state. It was very well presented. Do you have any comments from Judge Thomas or Judge Easter?
I want to thank everybody's cooperation.
I want to thank my colleagues, especially for allowing us to hear this case in August and sort of out of turn. I want to thank the lawyers again for the efforts that they had to make to get here. We're very cognizant of the ability to keep these cases on track and keep them moving. We don't want to get, if we can get them this month, we want to get them this month, because sometimes we lose this month. It might be 3 months down the road. So we are very, very mindful of trying to keep the cases on track. And I thank you for allowing us to do that. As always, we appreciate the office, Clerk Jim Hivner's office and what they do for us. And with that, thank you both for a very well presented argument. We will stand adjourned to the call of the August-September docket.
This honorable court is now adjourned.